Hi, everybody. Today's special guest is Attorney Jeremy Mutz from Florida. He is a former prosecutor with the Leon County Prosecutor's Office. He's a criminal defense attorney in Chipley, Florida, Florida State University Law School graduate, and a former coworker calls him a barracuda in the courtroom. So let's welcome Jeremy Mutz. Thank you so much for being here.
Well, thank you so much, Judy. It's an honor. I really appreciate the invite, and I've followed your program, your content over the last few years, and you've done some excellent coverage of this case. So I really appreciate it.
Oh, well, that's great because I never saw any other comments from you. So I didn't know if you had any idea who I was or whatever, but I really enjoyed seeing you on Surviving the Survivor, and it seems like you know a ton about the Dan Markel case. So can we start out by maybe you telling the viewers a little bit about your family background?
Well, sure. My father was in the military, so we kind of moved around different bases and settled in Fort Walton Beach, which is to the west of Hiawassee Springs, as our friend Wendy would describe it, smack dab in the middle of the Panhandle. And it's a little beach town in the Panhandle north of Florida. And then I ended up going to Florida State for law school. It was kind of always my first choice. I visited the campus as a young person, and you know, what do you know when you're 18? Really, I thought the campus was cool and I was impressed with it. Ultimately, it was a choice between Florida Coastal, and they weren't accredited at that time. FSU was, and I had a good friend also that went to FSU and liked the program. So I ended up going there to law school. And, you know, sometimes people come to Tallahassee and that may not be the place that they have chosen to end up, but because you're in the middle of all the state agencies and employment, state government, the Capitol, and so forth. A lot of the job opportunities were there, and that was the case for me. I was offered a job with the state attorney's office, the same one that's involved in the Markel prosecution, hired me before I even finished law school. I think I graduated on a Saturday and started on a Monday. You know, back in my final year, so. It kind of just fell into place.
Yeah, that's really impressive because there are some people who graduate from law school with no jobs lined up. So where'd you go for undergrad?
I went to the University of West Florida in Pensacola. For people not familiar with Florida, of course, Miami is at the very bottom southern tip. Pensacola is the extreme opposite west end of Florida, almost like night and day, which is kind of one of the reasons I think Wendy had some issues with being in Tallahassee. It's a much different culture and everything than South Florida, particularly Miami would be.
Mm-hmm. Yeah. Well, we had a bunch of questions lined up, but while we're talking about Tallahassee, you mentioned that you did read some of her book, This Is Our Story, which is semi-autobiographical. Can you tell us what Tallahassee is like since you lived there for a number of years?
Well, I did read her book several years ago when the case was really heating up. I kind of wanted to see if there was some particular insight into the case that could be learned from it. You know, you get Tallahassee is a kind of a culture shock. If you come from Miami, and I had some friends in law school that were from Miami, lived their whole life there. If you're used to that, if you're used to the beauty of South Florida, the beaches, the palm trees, the nightlife, Tallahassee is a bit of a culture shock, you know. And on a Sunday night, downtown is dead in Tallahassee, and it's much smaller. If you like high-end shopping, there's just none of that in Tallahassee. Now, the other side of that, Tallahassee being a smaller town, generally it's a good place to raise a family. Generally, it's a little bit more relaxed pace of life. It's not the horrible place that the book makes it out to be. Cockroach infested, you know, kind of, you know, redneck type of a place that she makes it out to be, like a punishment. The place that they actually lived, and for a while I lived one street over from where Dan Markel and Wendy, Dan Markel lived and where he was killed. That's a beautiful area. Benton Hills, beautiful homes. Tallahassee has 3 colleges, 2 large hospitals, all the state government, the capital. So it's a city with a small town kind of feel. A lot of beauty to it, the hills, the oaks with the Spanish moss, a lot of things that authors and people, you watch 48 Hours or you watch a documentary, they point to some of those beautiful aspects of our area. They call it the Red Hills area because there's, high hills and everything. But if you're used to palm trees and South Beach, then it's a radical difference. And I think that's what played into it with Wendy. And I think her career opportunities were probably not ideal in Tallahassee. And of course, being so far away from her family that she was so, you could say, wired into her family in an unhealthy way, but certainly connected to them.
Mm-hmm. Yeah. So it sounds like you knew about this whole case way back in 2014, as soon as Dan was murdered, right?
I did, but at that time I was no more than a spectator, and following it in the media along with everybody else. And it really was a mystery at that time, and it was a whodunit. And I think that's what captured people's attention so much, because we really didn't know. And I remember riding down the street, going into parking lots, going out to dinner, and seeing a mica colored Prius and thinking, oh, wow, could that be the car? So I was kind of, following it with everybody else. But as we got into 2015, 2016, I got more of an insider's view of it, because I was working in the same prosecutor's office that was handling the case and deciding what to do with the case. And so I had my own duties as a felony prosecutor. And then later I was a division chief and over some of the less serious cases, but responsible for supervising and training a lot of the new attorneys in the office coming just out of law school, and some with a little bit of experience. So I would be at the staff meetings in the office where Markel was discussed. What are we going to do about this? Do we have enough to charge? And, other people would tell me things as well that, man, this case is really hitting a roadblock within our state attorney's office. Here's what's going on behind the scenes. So I kind of got a feed of information on that stuff that I wasn't looking for. It just kind of fell in my lap, and then I would talk to people about it and try to help them sometimes. There were a couple points where I would look at things that the investigators on the Markel case were doing and just try to, they would sometimes be frustrated with what's going on and ask me about it. Like, why do you think this is happening? And I would try to just share my insight of what I thought, what I'd heard, because I felt they certainly had a case. I think they certainly had a strong case against Mr. Garcia, Mr. Rivera, Charlie, and Miss Magbanua and Donna, all from the onset of this case. But for some reason, it didn't go forward, or it went forward in fits and starts. And a lot of people have speculated about that these past 8 years.
Mm-hmm. Well, were there actually meetings where people were having conflicts with Willie Meggs, who I think he publicly did say that there would be repercussions if the police department arrested the Adelsons or did something. Do you recall any of that?
Well, there were several things that stood out. I know back in May of 2016, one person in the office confided in me that Mr. Meggs was being really stubborn on the case, and he didn't want to approve the search warrant. And that was on the original, before Rivera and Garcia were arrested. And the police department had to do an end run around him and go directly to the judge And then the judge said, no, I'm not going to approve warrants without the state attorney approving it. So the case was kind of stuck at that point. And at one point, Mr. Maggs was talking about sending one of our investigators to Miami to do it ourselves, to talk to, it may have been actually talk to Garcia at that point. And so there was not a cooperation going on like you would want in a homicide. And then at one point in late May, Mr. Maggs said in a staff meeting in the office that I was there for, do we have anybody smart enough to go down to Miami and do the interview? He asked. Do they have anybody smart enough, meaning the police department? And then in June, the police chief has to hang up on him on the phone because it's such a heated conversation. You know, so you can imagine the chief of police in your city has to hang up on the district attorney, the elected prosecutor. You know, and I can't get into the motives in somebody's head or in their heart, but that's not what you want in a murder case. You want the people tasked with and entrusted with the responsibility for it to work together. And if I'm the prosecutor and I'm Willie Maggs, I need to pick up the phone and say, you know, Chief DeLeo, your guys are working on this case. I understand where you're coming from on it. Here's what I need to successfully prosecute it. Y'all don't have it at this point, but I'm willing to listen. Instead, you know, it's kind of the disparagement. And then it culminates in that period of time where he says in the paper, to the newspaper, if you go ahead and charge the Adelsons, go ahead and do it. You don't need me, but get ready for a lawsuit. And I've said this before, there's not another example in the history of the state of Florida, going back to 1845, where an elected prosecutor invited somebody to sue his local police department on a prosecution.
Mm-hmm. And why? I mean, I guess you already said you can't guess at people's motives, but I mean, did he act like this with other cases? I mean, this is so bizarre.
I think it really could be instructive to compare it to other cases, because he has said in this case that he has a very cautious, judicious approach. He didn't want to charge anybody without all the ducks in a row. But then you look at another case that he did back in, I think it was 2011. He charged the elected Speaker of the House, Ray Sansom, with theft. And it was over a theory, a very novel theory, that a legislator, by appropriating a bill, if the bill wasn't going to exactly what it was described to be when it was passed, that appropriation could be theft from the state. And so ostensibly the bill that passed was an emergency operations center, I think in Destin, but it also had an airplane hangar with it. And Mr. Maggs charged him with a theft for building a hangar that he was supposed to receive some private benefit for. So you look at a case like that where you have to stretch the definition of a theft like a pretzel, and that went forward. But in this case here, I mean, you have, by the summer of 2016, it's very clear what happened in this case. And he didn't want to go forward, even with Rivera and Garcia on the onset. There's also, and you can look at the public records in the case, the original probable cause was kept sealed. And then somehow somebody gets a hold of the judge and an order is issued that unseals the probable cause, unbeknownst to the police department. And so their counsel has to file something, an emergency motion, to reseal that. But of course, the damage has been done. You know, anything that the Adelsons may have had, they have an opportunity to change their phones, dump their phones, go on the run if they should choose. You know, there's a reason why that was sealed, but somehow that got unsealed. And then fast forward to the fall of 2016, Mr. Maggs accuses the police department of themselves leaking information to force his hand. So you have all of this soap opera of stuff going on that, at minimum, it's not a good working relationship. And I think it's up to the prosecutors to make the relationship work with their police department. You know, if law enforcement doesn't bring us cases to prosecute, then we don't have a job to do. And it's that simple. They bring the cases, they make the cases, we prosecute them in court. But this was an antagonistic relationship, and I don't know the reason why. People have speculated about it. I've offered some opinion in the sense that Mr. Meggs made some statements to people that he was hopeful the statewide prosecutor would just pick it up, or the feds would just pick it up, and then he wouldn't have to deal with it. I don't know why, because as a prosecutor, that's like the Super Bowl. You get a murder case like that, that's kind of what you live for. So I don't know why you wouldn't want it. Other people told me, though, that he was concerned that big attorneys that the Adelsons could afford would come up to Tallahassee, and the office would be run from pillar to post with these really good attorneys. And I think that could be an explanation as well, but it's hard to get into somebody's mindset when it really doesn't make sense, because, you know, you and I are attorneys, and depending on what we specialize in, there are certain things that we specialize in. If we have to gear up for a hearing or a trial or something like that, that's kind of what we live for. And, you know, some of us that are not courtroom attorneys, we might have a big appeal, or we might have a big motion that we draft and we spend a lot of time on it. We kind of live for that. You know, we wouldn't say, you know, gee, I don't want to do this because I'm going to have to go to a hearing or go to a trial or write something. It's kind of like, why are you? It would be like a surgeon that would just fear surgery and say, oh, I don't want to do that. I don't want to cut anything open. Or why are you a surgeon then?
Mm-hmm.
And
Yeah.
so a lot of that, I think, factored in. And, you know, Mr. Meggs went through the whole situation with Jameis Winston, where some big attorneys came in, all of the media came in. And, you know, I think there may be something to say that he didn't like all that media attention on the office and having to respond to all of that. I think it could be some of it. Stubbornness could be another, in the sense that, you know, some people just don't like something if it's not their idea. There's long been an antipathy between Mr. Meggs and the police department, you know, going back to the 1960s, where his boss didn't think the police department should even have detectives. They thought all serious cases should be worked by the sheriff. And, you know, was it something where they didn't want the Tallahassee Police Department to get a good headline for the Markel case and resolving it? It's really hard to say. I think there may be some of all of that, and there may be some other reasons why. But nowhere else, and I would invite people to search the microfilm of newspapers, nowhere else in the history of the state has a prosecutor said, go ahead and sue my police department over this.
Mm-hmm. Yeah. So there were definitely a lot of people that were pretty upset about the way Meggs was running things or handling the case. Okay, so from what I've heard, Willie Meggs retired and he's raising turkeys on a farm. Is that true?
Well, he did retire in 2016 or so. He handed it over to Jack Campbell, who won election twice subsequent to that. And I think he mentioned something about the turkeys in Over My Dead Body, the podcast. That was something that came up in that. And, you know, good for him. I hope he's happy in retirement and getting to enjoy the outdoors and turkeys and all that stuff. That's wonderful. But I think in this case here, by delaying it as he did, he set it up so that Magbanua, I'm sorry for mispronouncing that, Katie had to be retried twice, where I think if they had charged Donna, Charlie, Mr. Rivera, Garcia, all of them at once, I think the dominoes would have fallen initially for Katie to testify against the others. I think by piecemealing it and doing it kind of in fits and starts, dribs and drips and drabs, I guess is the saying, it forced it to go the way it did. And you know, better than anybody, in the first trial of Katie, the jurors had a problem with the fact that here's a young woman, a mother, person who's a minority. She's charged, but the wealthy white dentist family has not been charged, and they had a problem with that. And I think the second time around, they could see that the other people were going to be held accountable in some way. They had less heartburn about convicting her for her role in this. And I think if we had the police department and Mr. Maggs working together in 2016 and the dominoes fell as they should have, we wouldn't have had to be trying Katie twice. We would have had her testimony, her cooperation initially, instead of going through 2 trials and now a proffer to see what she's going to say. And her credibility may not be good, even if she does testify now. We got it completely, out of whack. Whether it was a personality issue or stubbornness or just, ego or whatever it was, it prolonged this. And I think it made the Markel family, their path towards seeing justice done. I think it prolonged that. And I think that's a hard thing to come to terms with. That's something that bothers me, and it's bothered me, for several years.
Mm-hmm. Yeah, but to answer Roxanne's question, he can't be held accountable, right? Because he had that discretion and he has immunity, right?
State has immunity in all but certain very limited exceptions. Police department, police chief, prosecutor, they have immunity from any kind of suit.
Mm-hmm. Yeah, that's what I figured. Yeah. Let's see. So people are leaving some comments. Thank you guys all for being here. I did wanted to ask you about the decision not to wiretap Wendy or Donna. Do you know anything about that, or are you able to say anything as to why? Why weren't they wiretapped? I feel like they should have been.
It's interesting. Mr. DeCoste in I think it was the trial in 2019, he asked that question. But I think it goes down to, you have to be very targeted in wiretaps. And I think prosecutors are very careful typically, and even asking for a wiretap. They want things to be just right. I think because they had 3 going in this case, they may have felt like we can't ask the court for a 4th. They got quite a bit with the 3. I mean, they really got a lot of information with the 3. So I think it may have just been a reluctance to push the court for a 4th, because the courts are going to be very targeted. That really is an invasion of somebody's privacy. It's hard to imagine anything greater than getting into your phone. I mean, that's like literally looking over your shoulder from government. So it's a very heightened threshold that you have to meet, or you should. And so I think that may be the reason. I don't have any specific insight beyond that. And I think Mr. DeCoste sort of posed that as just posed that for effect at trial. I don't know that he elicited anything beyond that at trial, as I recall.
Mm-hmm. Okay. Let's see. Oh, do you know anything about any sort of relationship between Meggs and Adelson's, Wendy Adelson's godfather, who was Weinstein, right? A judge.
Mr. Weinstein, Judge Weinstein was a judge in maybe the West Palm area. And then his son, I think it was, ran for state senate, and I think may have served in the state house or senate. So people have speculated about that, and I think it's just, all you can say is it's fodder for speculation, because they were involved in Democrat politics. But I don't know of anything more close than that to link them together. I think people have tried to connect the dots on that, but it's more just I think a lingering series of dots on the map that you're trying to connect, but I'm not sure that there's anything that really connects it so far.
Okay. Someone wants to know, do you know Charlie's attorney, Daniel Rashbaum?
I don't. I mean, I think he comes across well. I think he comes across pretty reasonable and effective. So I would not underestimate him. I think that's the biggest mistake one can make as an attorney, is to underestimate their opponent. And I think one of his demeanor are sometimes the most dangerous. You know, sometimes it's the quieter, kind of more low key people that you really have to watch out for, you know, because they can get a lot of credibility with the jury, where sometimes being cocky does not always play with the jury. Being too confident sometimes is a detriment. And I think he kind of has a nice, you know, easygoing demeanor to him. So it'd be interesting to see how this works at trial and how he does through the length of the trial. I don't know him personally.
Mm-hmm. Okay. Yeah. So I did want to ask you about this situation that you probably have heard of, that apparently on a wiretap call, Donna was talking to Charlie and saying that Wendy's judge, who was a federal judge that she was clerking for at the time, was getting information from a judge in Tallahassee. Do you feel like commenting about that, or do you have any guess as to what could have been going on?
Well, you know, it's interesting. The world of judges, it's a small world in Florida. You know, there are not that many of them really. So people know each other. People have been in law firms in the same city. People have served on committees together, worked for the same state agency. So the legal community in Florida is small. Paths cross. The specific ties or the specific person, I don't know. I think couple that, though, it's interesting maybe to couple it with the fact that what happened with the records being sealed, the judge on his own unsealed them, and then the police department had to file a motion to get them resealed. Some people say, you know, did somebody pick up the phone and try to pressure the judge to unseal them? Does that happen? You know, the average viewer may say, well, the judge is the judge. How can anybody pressure him or her to do anything? Well, that does happen. You know, sometimes things aren't as formal as we may believe they are. And sometimes I've seen it happen where somebody will pick up the phone, and I've seen Mr. Meggs do it, where he'd pick up the phone and call a judge, you know, I think you should do this. Mm-hmm. And there was a DUI case, for instance, where he wanted something changed in a sentence on a DUI defendant. He called the judge, you know, I think you should take the interlock off this person's sentence. So did somebody call that particular judge and say, hey, you know, I think you need to unseal this. Judge, I think you're looking at trouble if you keep this sealed. The media has a right to know. And the judge probably would say, well, is the police department okay with this? You know, they're going to be fine with it. I'm telling you, they're fine with it. They'll do what I say. Couple that with the judge I clerked for had a conversation with somebody, and then it kind of connects another, well, it kind of suggests another dot. But again, I can't connect those dots to any specific person. That'd be speculating about mm-hmm. that. And, you know, I think the judge that unsealed first sealed and then unsealed the order, he's a good judge. He's a good man. But I think we're all human. If somebody calls us in that way, you know, Judge Jeremy, you know, you've got this thing, you know, you've got some problems. If you keep this sealed, I think you should go ahead and unseal it. I mean, we're all subject to that, you know. Mm-hmm. I like to think we would always be tough and say, you know, I'm going to wait to unseal this until I hear more. But I can't connect the dots any further than that because I don't have that information.
Mm-hmm. Okay. Yeah. Similarly, Chuck has a good comment here. Actually, I think Chuck is the same person who wrote on the Facebook group that he read your first book and absolutely loved it. So Chuck is retired law enforcement in Florida. So
Well,
he says,
I appreciate that.
Yeah. Was the organized crime connection since Luis Rivera's Latin Kings underboss triggered the FBI involvement and widened the scope of the wiretaps? Do you think that had anything to do with it?
I don't know the original predicate for the FBI getting involved, but I think Chuck is hitting on probably why they stepped in. You've got the gang involvement, the Latin Kings. You've got a lot of money potentially being used for a hit across the state, and I think that would be something that would raise that would get on the FBI's radar screen. And I think also the fact that you had, I believe in this case, the Tallahassee Police Department sought FBI's assistance, if I'm not mistaken, because of this being a case crossing the state and could potentially be racketeering, could trigger some of those statutes for the feds. But it's also something that you would really want the FBI in on. I mean, that's kind of what the FBI is good at, of a case that just crosses many jurisdictions and they can use their resources on it. So I think Chuck's hitting on something. I just don't know the specific details of what their first thing that opened the door for them or got their foot in the door.
Mm-hmm. Okay. Peach Lilac says Judge Hankinson said in Meg Banua's first trial that conspiracy laws were outdated. I wonder if this will prevent Wendy from being convicted. So, of course, that's a big question everybody wants to ask you, because I saw some comment you had left on the Dan Markel Facebook group a long time ago saying that you didn't think Wendy would get charged. Do you still think that?
I do. I think the odds are pretty low. I think maybe 1 in 5, maybe a 1 in 5 chance that she's charged. I saw some of your content with Fancy Fiction, and I think y'all made some good points about, for now, the state needs her to testify. And, you don't want to box her in. You don't want to dirty her up with a charge where she can't testify then. And some of the things that y'all mentioned, I agree 100%. The divorce records, some of the statements that were made to Mr. Lacoste, Jeffrey Lacoste, about hiring a hitman. You may need her to testify. I've always felt the evidence against Wendy that's the weakest case. That's the hardest case to make. I think it's there in spades for Charlie and for Donna. Mm-hmm. And I think it's been there since pretty much day one. But Wendy's harder, and I think they walled her off to some extent. They gave her some plausible deniability. They were smart. Do I think that, Jack Campbell, the current prosecutor, says, people shouldn't get away with murder just because they're smart. And I agree with him on that. But sometimes if you don't have enough evidence, you can only do it once. Mm-hmm. If they're acquitted, you can't try them again. I think it's unlikely, though, in Wendy's case, they'll try her, really, because I think once they do Charlie, I think they're going to stop with Charlie. And I think they just don't have a lot of incentive to do Donna, Harvey, and Wendy, even though I think they could successfully prosecute all of them. But I think they felt like they had to go forward on Charlie. The evidence was clearly there. Their best prosecutor, Georgia Kappelman, thought it was there. They were able to enhance the video. There's no prosecutor in the state that could look themselves in the mirror and not charge Charlie. But I think they may wrap that up and say, we got the shooter, we got the driver, we've done something with the middle person, Miss Magbanua, and we've got the one that was the brains behind this, the callous one that set this in motion and thought he was big time pulling the strings, getting a hitman. We've got all these people. That's as far as we're going to go, and there's just no political reason to go forward with more. And I think it's unfortunate, but I think that's probably where they're going to end up.
Wow. Well, I think people are getting upset there, but, well, what if in her proffer, Katie had actually said some more stuff against Wendy and Donna? Like what if Katie said something like, oh, well, Wendy met with me multiple times and she told me that she was going to help get that money together. And she gave us Dan's schedule and she told me the job had to be done because he's going on a trip to New York on Saturday. Do you think that would be enough, just the verbal extra testimony of Katie to bring charges against Wendy? Or do you think that's not strong enough?
I think it could be enough, and I think there may be other surprises in her proffer. There may be other surprises in the 55,000 pages of records that were alluded to after the last trial by Mr. Ashbaum and Ms. Kappelman. There could be more that we're not privy to in the public. I think really right now there's enough on Wendy. Would that push it over the top? Would that suggest to the prosecutors that we really need to go forward with this? We need to complete justice for Dan Markel, his family. Would that drive the train forward? And I don't know. I think there were a number of things that drove it forward for Charlie. And I think it was just so crystal clear that you couldn't let this stand. You can't let somebody just come to your city and plot a murder, hire a murder, shoot somebody down in cold blood in the driveway of their home and let that stand. And when you have this much evidence, you really can't justify that. And I think there are some political things that factored in as well, in the sense that you prosecute two gentlemen that are of Latino or Hispanic descent. You prosecute a young woman who's a young mother, and she's of Filipino descent, but you're just going to stop there and you're not going to go after the one that really pulled the strings to it. And I think there's some politics involved in that. They have to justify that. 2020 was an election year. For politicians, nothing else matters if you don't get reelected. And in Florida, the state attorney is an elected position. So you can have a lot of noble aspirations, and there certainly are some in this case. But if you're not elected, none of it matters from a politician's standpoint. So they have to do certain things to have a case not be a detriment to their reelection or to their office. How far do they go on something? Well, does it help them or hurt them politically is a factor, and I think Mr. Meggs' calculation probably was that Mr. Markel's family are in Toronto. They're not voters in Florida. It's not going to help him or Mr. Campbell get elected in 2016 to go forward with this. I think you can't divorce those things. And I think to Mr. Campbell's great credit, to Ms. Kappelman's great credit, here with Charlie, they've decided to go forward with the evidence that they have, the enhanced evidence. But this is never entirely just the facts. It's never that clear cut in this case. And with this particular state attorney's office, it's not always about just what the facts are and kind of putting those in a vacuum and sort of an ivory philosophical tower, academic tower to say, if you have X, A, B, C, and D, you prosecute. If you don't have D, E, and F, you don't prosecute. It's just not that simple and clean, unfortunately. And I'm not sure the public always gets a window into that. But we're in Tallahassee. This is the capital of the state, and everything is political.
Mm-hmm. Okay. Well, just to get a little bit technical here, I did want to ask you about the hearsay problem where, let's say Lacoste wanted to testify that Wendy told me, whatever it was, 5 to 7 days before Dan was murdered, that back in 2013, Charlie had looked into hiring a hitman to kill Dan. So I was always thinking, wouldn't that be inadmissible hearsay? Like, what do you think?
Well, and it's called double hearsay because you have one person saying something that somebody else told them outside of court. Mm-hmm. So double hearsay. If I tell you something that's outside of court, that's one layer of hearsay, but now you have two. So you have to meet an exception to hearsay for each of those layers. And, you know, people study hearsay their whole career. You know, law professors study hearsay, teach hearsay their entire career. So it's a complex subject. But essentially, in this case, in Florida, Rule 9803 is an exception to hearsay. If I'm in a conspiracy with somebody, the things I say outside of court in furtherance of that conspiracy are admissible. So that takes care of Wendy's layer of hearsay. If I'm talking about a hitman, that's a statement against my interest as Charlie. That's another exception to that level of hearsay. So you have an exception to one layer, an exception to the other that allows that to come into court and be admissible and heard by the jury. There's a co-conspirator exception in the Florida rules and the federal rules. Florida's 9803, federal's 801, Rule 801. In addition to that, there's exceptions for something that's offered not to prove the statement, but just to prove that such conduct occurred. It's called a verbal act. So if I'm saying I'm not in a conspiracy, but I mentioned hiring a hitman to somebody, that refutes my statement. And so it could be relevant. It could be admitted as hearsay. Even though it's hearsay, that's an exception to it. And, you know, there's a case, for instance, involving General Motors Corporation back in the 1950s in federal court. There were letters from customers that were offered a reason for the cancellation of the dealer's franchise. And they didn't admit the letters to prove the contents of that letter, but just the fact that that verbal act was made and that there was some other reason why the dealership would be canceled. So it's that kind of an argument. It's quite technical and complex in some ways. And, you know, the state will be trying to get all of those statements in. Another way the state gets around hearsay is by calling Wendy as a witness. There, you just have one layer of hearsay because Charlie's statement then is an admission that goes against his interest. That would come into evidence as an exception to hearsay. Wendy's testifying, so she's not a level of hearsay. And essentially, all hearsay is if I say something to somebody outside of court, generally that's not admitted into court. I would need to say it in court in front of the jury so they can evaluate what I'm saying. Or there needs to be some of those exceptions like an admission by a party opponent, or, you know, if I'm in a conspiracy with you, they don't get to hide behind hearsay. If you and I are meeting at a restaurant talking about killing somebody, we can't just hide behind and say, oh, well, you can't say what Judy said in that restaurant because that's hearsay. Well, okay, but otherwise we could sit there, talk murder, and there's nobody can ever say anything about it. And the courts have said, no, that's an exception where we're not going to let that happen. So I think it comes in, but at every step, a good defense attorney is going to try to keep it out and say it does not meet the exception for conspiracy. Or, you know, if they call Wendy to testify and she denies.
Yeah, I think she would deny it. I don't think she agreed that or admitted that she had actually said that to Lacoste. She just said it was a joke. There was some joke about buying me a TV being cheaper than hiring a hitman, but that's it.
And so that what you just said is minimization. Yes, I said something like that, but I'm minimizing what it is. So then you call Mr. Lacoste to impeach her testimony and say, well, yes, you did mention it. It was not in a context of joke. A good defense attorney is going to say, well, you can't just call a witness to impeach her. You have to have a forensic purpose in calling a witness under case law. I can't call a domestic violence victim that I know is going to lie about everything just so I can try to impeach her with another witness. I have to have some legitimate purpose that I expect her to tell the truth, and I expect, there'll be some things that are material to the case. They're going to come out through her testimony. I can't just put somebody on the stand that I know is going to deny everything just so I can call the other witness that I really want. I think the state gets around all of those hurdles, but I think a good defense attorney is going to attack them. And it's never as clear cut as, some things, because hearsay is a complex issue. There probably will be, arguments in the middle of trial about this.
Mm-hmm. Or motion and limine, most likely coming down the pipeline.
I think it almost behooves the attorney, Mr. Rashbaum, to try to do that. But I think it comes in because, she is an unindicted co-conspirator, and these statements are clearly material to a conspiracy amongst, whether it's amongst Charlie, Donna, Katie, Rivera, Garcia, or it goes further than that. This is a conspiracy that, these statements are made in furtherance of or descriptive of. So I think it would come in.
Okay. Thank you. Okay. Angela has a good question. Why name them, meaning Donna and Wendy, as co-conspirators in paperwork, which was a motion in limine in Katie's trial, if there's no chance of an arrest? Is there a grand jury involved to see what they think about indictment?
Well, I think it could be just what we were talking about in terms of some of the evidence that there is a broader conspiracy, and, there may be strategic reasons to identify that. But I don't know that it would. In federal court, it's pretty common to have unindicted co-conspirators. That's not unusual. It's more unusual in state court because state prosecutions generally don't get that large, that you have a bunch of people that are not charged, but they're in the periphery that did certain things in a conspiracy. But in federal court, that's not unusual. And I don't know that I don't know that it's a tell one way or another in this case. There may be some strategic reason in what we were just talking about, in the sense that if we're talking about some of the acts done in furtherance of the conspiracy, we want to ensure that's admissible in court, and this, helps us do that.
Mm-hmm. Okay. Okay, good question here. Everybody wants to know, what do you think is in Katie's proffer? Just a guess based on your knowledge of the case so far.
I would not be surprised if she didn't try to minimize certain things and just go only far enough to try to get something worked out to help herself out, but not go so far that she really gives all the goods on the Adelsons. But it's really hard to do that. I mean, I would love to have been a fly on the wall to hear that and see her demeanor and just see how she came across. 4 hours does seem kind of short, given the magnitude of what we're talking about. I think it wasn't Wendy's interview with Isom about 2 hours long,
or 5.5 hours, maybe.
All together with her waiting there and so forth. So, I mean, here we've got somebody who could break this case wide open on one level, and it only takes 4 hours. But it's not entirely telling, because, I mean, you could hit all the key areas in 4 hours. I mean, we've talked about a lot of the key areas of this case in a few minutes. I mean, you could ask her, did you have this meeting how did things go with the exchange of money? Is that what happened at the apartment? You could really cover some things in 4 hours that would tell the prosecutor, is this person being genuine and are they being forthcoming? Because that's what they're looking for, is she's cooperative. But I would not be surprised at all if she just kind of went in there and only gave them as much as she thought she could get by with. But time will tell. I mean, nobody can really predict that. I'm not surprised at all that it would be sealed. I think that the judge doesn't want to take any chances with this being appealed, so they're going to keep this under wraps. But I do have some big question marks along with everybody else, just the shortness of it. And, we seem to be in a holding pattern with this happening. Everybody kind of was excited that this was going to be really big, but it's almost kind of like, Y2K is going to be the end of the world. And then it happens and the VCRs still work. And that's kind of like what we have here.
Mm-hmm. Yeah, it's definitely very frustrating. I mean, do you take that as a bad sign that Katie's proffer maybe wasn't that helpful since Donna hasn't even been arrested?
I honestly thought even before the proffer that the state has enough to go forward on Charlie. They don't really need the proffer. I think where they would need it would be if they go after Donna and go after Wendy. So from that standpoint, the fact that we don't have something that really crystallizes that they have all this new evidence or this, they fill in the gaps. Preston Scott was on one of the shows, I think maybe Surviving the Survivor,
yes,
where he talked about, Katie could really fill in some significant gaps that we don't have. We don't have direct testimony of. So with that, if she can fill in those gaps and then we don't have a prosecution of Donna or Wendy, that would be pretty disappointing. But at this point, I mean, we're all kind of just on the edge of our seats, just waiting to.
Yeah, just guessing, because it makes sense that they are not going to arrest Wendy since they need her to be a state's witness for Charlie's trial, right?
Definitely can't fault them on that. And because they've come so far with the way things are, they may not want to muddy up the waters by arresting Donna before the trial. I can't fault them for that. My bone to pick with them was just the initial 2016 timeframe. I think they should have charged Charlie, Donna, Rivera, Garcia, Magbanua all at once. And then I think it would have fallen into line where you would have had Katie cooperate. And then you can decide if you have enough on Wendy at that point. I think it would have been a lot cleaner. I think it would have been a lot less. These cases generally don't get better with age. I think, law enforcement did some tremendous work with the wiretaps and the bump, and then they did a great job enhancing the recordings. But, none of that was necessary to, the enhancement certainly wasn't necessary to go forward with the case.
Mm-hmm. Okay, just looking through these comments here. Yeah. So what interested you in this case? Because you clearly handled tons of other cases when you were working for the prosecutor's office. Did you even know Dan Markel or people who knew him?
I knew people that knew him, and I know people that know Wendy, but I was never in his class. He became a professor several years after I graduated from law school. So I didn't know him firsthand. To me, it's just the fact that, you could have somebody, number one is a murder case, a mystery case, and I love mysteries along with everybody else that loves true crime and loves mystery novels and everything like that. So that drew me to it. The fact that, there were suspects that were being looked for, and we were trying to figure out who did this back in 2016. That drew my interest initially. And then some of the things, like I said, stuff that I really didn't go out looking for. People started talking to me about the case, telling me what was going on behind the scenes, almost like I was, you know, behind the curtain, behind the stage kind of thing. And that heightened my interest as well. And I thought, you know, justice must be done. And it's kind of like the old British decision. Not only must justice be done, it must be seen to be done. You know, it was something that I felt strongly about and wanted to see justice done for the Markel family. And, you know, we don't want to, I don't think it doesn't matter what city it is in Florida. We don't want to let that stand if somebody can just hire a hitman and kill somebody in a custody dispute. If a prosecutor's office doesn't do something about that, then they might as well just close up shop, and we could use the money for something else. So I think if you don't do something about that, then, you know, you're really remiss. So that got me interested, and I followed the case since then, just kind of along with everybody else, and watched the trials, and, you know, have waited to see just along with everybody.
Okay. Now, you did mention that you know people who knew Wendy. Do you feel comfortable saying whether those people seem to think Wendy had nothing to do with Dan's murder?
Well, I know one person in particular that was another professor at FSU Law School, and thought that she had nothing to do with it. Thought that she was a very nice person, and just saw no signs of her being capable or even giving tacit endorsement to such a thing. And at first, I was kind of really wanting to give Wendy a lot of benefit of the doubt, just because of some of the people such as that vouched for her and said there's no way she'd have anything to do with this. I wanted to give her the benefit of the doubt, and did for a number of years. But after the second trial, when I saw some of the calculating behavior, you know, wearing the same suit, the same suit that she wore in the first trial, things like that.
Or making up stories about how she was relieved when her motion to relocate was denied, and, you know, just talking about why she supposedly wouldn't let the Markels see the children after a couple of years after Dan was murdered. You know, there are just multiple things that happened on the stand, because I think even the people who ran the Justice for Dan Markel's Facebook group, even at first, they were kind of behind her for the first couple of years.
I think they were kind of just trying to give her the benefit of the doubt, maybe.
Mm-hmm. Yeah, she was the grieving widow.
But you're exactly right. And I think the minimization, number one, I mean, if I'm murdered, I want my spouse to say, you know what? We were in a horrible divorce. It was ugly, but, you know, they're the father of my sons. And, you know, I want to make sure his killer's found. I mean, this is horrible. Not, you know, circling the wagons and minimizing things. And really what all fits together now after the second trial, I think, is very clear. You know, and that's just not behavior that an innocent person would exhibit. You know, changing your phone number because you think you're being wiretapped and things like that. You know, innocent people don't need to throw away their phone or get a new phone number. Mm-hmm. And, you know, innocent people don't need to hire another hitman when an undercover officer comes up and says, you know, you haven't taken care of Tuto like you've taken care of Tato. Oh, well, let's go hire a hitman to whack those guys. Is that what innocent people do? And, you know, I think with Wendy, it's just incredible. Looking back at it now, her interview, you know, it's not, I'm going to do everything I can to help you guys find who killed the father of my boys. That's just not her mindset. And to me, that's more than just being problematic or odd. That's, I think, tends to be incriminatory when you add up everything else.
Mm-hmm. Yeah, but ultimately, based on what we've seen so far, you don't think that would be enough for the state attorney's office to actually charge Wendy?
You know, I know it'll disappoint people, but It may not be, because, you know, it really is a high burden to charge somebody with a crime. A prosecutor needs a good faith belief that he or she can prevail at trial and convince a jury beyond a reasonable doubt. It's not enough if we don't like somebody or we don't like their behavior. It's not enough if we think they're guilty. It's not enough if we're like 80% sure that she's involved. To be beyond a reasonable doubt, that's like 92 to 100%. And it has to be there. I think it's there for the other folks that we've talked about, but, you know, I think Wendy was smart enough. She kept some distance. And just think about this one piece of it. We all, I think, are probably pretty convinced that the TV was a code. This TV is going to be 5,000. We had a TV repairman come to look at the TV. That was her alibi. Well, just because you have Best Buy come and look at a television, that doesn't mean you're guilty of murder. Some of these things really are subject to dual interpretation. And so that's automatically a reasonable doubt.
Yeah, she can explain away a lot of things, you know, like how she said it was nostalgia. She was feeling nostalgic, so sometimes she would drive by Dan's house or go back to the old neighborhood, right?
You know, there's so many things. I think maybe she's even toying with law enforcement with the owl shirt and things like that. So many things that are jarring, like when she did the podcast and she called Dan her latex husband.
The latex spouse. Yeah.
Again, you know, different people handle grief and stress differently. I understand that. But most people, the father of their children is murdered. She's having to help those boys through that grief process, that loss. You're not going to make jokes about that. In a public setting, I mean, you may blow off steam with your friends, but to put that on a recording and things like that, I mean, I think it gives a real insight into her. And but those things alone, you can't convict somebody based on not being a nice person or not being a thoughtful person, latex spouse, or, you know, gibbers or these other things.
Yeah.
You know, it would be a totality, and it would have to be really this mosaic of evidence would just have to be threaded together so well that the jury would see it and be comfortable with it. And I think it's a lot harder to get there with Wendy.
Yeah. Yeah. I feel like only Katie would probably be able to, or Siegfried maybe would be able to bring forth more evidence against Wendy's involvement. So that we don't know. And my college friend, who's a prosecutor in California, he said that he thinks it's pretty unlikely that Siegfried is going to help out the prosecution. What do you think? Do you agree, since he's already been convicted and sentenced to life?
I think it's very unlikely. There's nothing much he could do to help himself. You know, I think that could there be a possibility he would do something if it helped Katie? Doesn't seem very likely. I don't think the prosecution would really want to start reopening all of these cases to set that precedent. I think doing it with Katie is unusual enough, but I think it's worth exploring. I mean, if I was sitting in their shoes, I would take the proffer as well. But I think it would be, you know, very hard to start doing that with, especially the person that actually pulled the trigger. Mm-hmm. You know, make a deal with him. I think would be very hard. I don't see them doing that. But in his mind, perhaps if he had a way of taking time off of Katie's sentence, that could be something.
Yeah.
If he has the nobility that we I think romantically we want to.
Yeah, but he's just a cold-blooded killer who thought nothing of just going up to someone and putting 2 bullets in his head. Yeah, and he was taking a lot of drugs at the time too, so who knows what he can even remember.
Because we think in some ways, he had this great love for Katie and would do anything for her to help her. And it's almost like I think as humans, we want to keep that romantic idea somewhere. But if he really loved and cared about her that much, he wouldn't have dragged her into this or let her do this. He would have said, you know what, I don't care how much money your dentist boyfriend is offering, who's going to take care of our kids if you're in prison? That would be a
stupid idea. Yeah.
I mean, that would be what most responsible people that love somebody would hopefully say. You want me to kill somebody for your boyfriend, dentist boyfriend's family and his sister. They're going to pay us $50,000. What happens if we get caught? So we may be really stretching to say he would fall on his sword to cut a few years.
To help Katie and say something against Wendy or Donna. Yeah, at this late hour. Yeah. Well, getting back to Katie's proffer, though, some people have asked, is it true the state really had no obligation to give the proffer to Rashbaum unless it had exculpatory info or unless they planned on calling Katie?
I think that they would be on really shaky ground to argue that they didn't have to turn that over in discovery. Florida discovery rules are very broad. I mean, pretty much if in doubt, you have to turn it over.
Okay.
If you even have to ask the question, you need to turn it over under Florida rules. But the ultimate, the floor of that rule is exculpatory evidence under Brady, is the United States Supreme Court case. If I have anything that's even remotely exculpatory of the other side, I need to turn that over, or I can be sanctioned for it. It's just the right thing to do because we don't want a trial by ambush. If we have something, just even a tiny thing that the defense can use, we have to turn that over. I don't see how they could hold this back. There may be some very limited circumstances that, something could be privileged work product, but generally an interview with a witness is going to be discoverable.
Okay. So it doesn't really lead you into thinking like, oh, there probably was exculpatory evidence in there because they turned it over versus, oh, they are going to call Katie because they turned the proffer over.
And exculpatory can be pretty broad, because exculpatory doesn't necessarily mean, an alibi. Like, Charlie was in Tibet and had no access to communications during this period.
Yeah.
He was in a monastery or something. That it doesn't have to be that dramatic. It could just be something that, Katie was talked to by law enforcement one other time and maybe fed her something to say, at the jail. It could be something minor. It could be something that really is not that strong at all, but it's still considered exculpatory. So I think that would be hard for them to not turn it over. There may be some limited exception out there that, if let's say they talk to a child witness or something and it turns out the child didn't know anything about the case, there might be some way of protecting the anonymity of that witness or what they said. But I don't see that happening with this.
Well, speaking of children, one of the commenters did ask, is it possible for the investigators to speak with Dan and Wendy's kids? I mean, I think that's pretty unlikely, but what do you think of that?
You know, the longer this goes on, that could happen. But, you know, it would probably take a court order, take a subpoena that they would have to be subpoenaed to come in and testify. I think it's very remote, but it's interesting to think about. I mean, I think as a prosecutor, sometimes you should think outside the box. And if this case was brand new right now, and the boys were close to being teenagers, and this was a brand new case, that might be something you really strongly consider because they're old enough to provide a lot of information. What would the utility be of the information that they were privy to, as I think they were maybe 3 or 4?
3 or 4, yeah.
You know, at the time, I don't know that it would be something I would want to do as a prosecutor, to try to drag them in to say what they've been exposed to over the last several years, what they've heard.
What did you hear? Yeah.
You know, I think that's something that you really don't want to do. You don't want to bring the children through that. I think they've been hurt enough by the loss of their father. I think there's no win in this if their mother's prosecuted for them. You know, for the kids to lose both their parents is not something that I take lightly. And if I don't have to sort of drag them through something like that, I wouldn't really want to. But, you know, there may be some circumstances where you would, like if you had some indication on the wiretaps or something like that, that one of the kids had an episode where they were screaming about, you know, you killed my father, and, you know, they really do know something about it, maybe then you would have to do that, because getting justice, you know, requires a lot of sacrifice on a lot of people, you know, and it's a heavy price to get justice in a case like this. If a child really did hear some of those things and you had a good faith belief to do it, I think you could do it.
Okay. Let's see. I have a couple of questions that came in from the people on one of the Dan Markel trial Facebook groups. So the first one is Anna. She asked, do you think the delay in Charlie's trial benefits the defense or the prosecution, or does it not matter? I thought the longer the trial is delayed, it is bad for the prosecution because memories get worse, or they could become ill or die. Well, any comments?
You know, there's the old adage that these cases don't get better like a fine wine with age. And there's also, you know, the old Rolling Stones song, "Time is on your side." That's kind of the defense standpoint. Sometimes the longer these things drag out, the better for the defense. I don't know in this case that it's going to make too much of a difference whether this trial goes, you know, whether it went in June, November, late October, November, as we're on track for now, or whether it goes in the spring or sometime. I don't know that time range really has an advantage or disadvantage for either party. But generally, you know, the older a case gets, you're exactly right. You know, witnesses their memories can fade. They can move. You know, I've had cases where witnesses were killed in a homicide, and we can't call them any further. So things like that, you know, generally don't make it better. But this is an unusual case. You know, they could rock along and the state uncovers more evidence that helps the prosecution. The volume of it, and we've, as the public, we've learned about this case in stages, you know, and I've said before, the case that we have now is not the same case we had in 2016. It is a lot stronger. Law enforcement, Ms. Kappelman, they worked really hard to make the case better. So there could be some things that they pour through. Sometimes new people, you know, if I look at a case, I may see some things that stand out to me, but hand the case to you and you see some things that I didn't think of. And so you might be able to present the case more effectively or argue that point more effectively. Sometimes trying a case a second time, a good attorney will not take it personally that they have to do it again. They'll try to say, how do I do this better? One thing that's most impressive about Georgia Kappelman is that second time around, she really made her arguments better in her closing, and she really addressed what were perceived as weaknesses in that first case. And it was a quite a startling difference. And I think that's a mark of a truly good attorney. That's what we should all aspire to, because we all have egos, and there's a tendency to say, well, they didn't get it the first time. You know, those jurors were dumb. And well, no. What did the jury get hung up on? You know, literally, they almost hung. What was it they had a problem with, and how can I address that the second time around? And that's what Ms. Kappelman was able to do.
Mm-hmm. Yeah, that's right. Because I thought I read somewhere that one of the jurors was also kind of offended that, was it Kappelman or one of the attorneys referred to the breast surgery as a boob job? I mean, go figure what people get offended by.
I think I did hear that. And
yeah,
you never know. They could say, you know, I don't like that tie that attorney was wearing. And, you know, I don't like his bald head. And, you know, it's
or that person's attitude, or it seemed like he didn't like me, you know.
There's so many variables like that. And that's why I think drama is probably the best preparation for being a trial lawyer, to take drama training, to really know how you're perceived and how you come across, I think is very important. You know, I think some of the best attorneys are really able to just talk to a jury like they're having a conversation. And in that sense, you're really in tune with them. And I think it requires a lot of thought, you know, of who you have as your co-counsel, how you present things. I've heard juries looking at the shoes of the attorneys. If somebody's shoes and suit was too expensive, they didn't like that.
Yeah, they think the person's too highfalutin and not accessible or relatable. Okay, one more question from Diane. She said, if you were in Georgia Kappelman's place, at what point would you decide that this is the case, as long as it's as buttoned up as it's going to get, I have to move forward? Well, I mean, you said that you didn't think they would go forward, even if Charlie is convicted, though.
I think
against the others.
You know, I think there's a good chance of that. I mean, I think Ms. Kappelman herself, and I know back in 2016, the consensus among the division chiefs in the office was to go forward on the case. And I think, and I can't read Ms. Kappelman's mind, but just what I knew of what was going on at that time and listening to her public comments over the years, I think she would go forward with them. But she has a boss, and so she has to, you know, work within the parameters of what her boss says. And I think, to Mr. Campbell's great credit, he decided to go forward on Charlie, but there's no guarantee that he'll do so beyond that. And in fact, I think there's a pretty good chance that it stops with Charlie. I hope they don't make that decision, and I hope that they follow just what the evidence is. And even if it's a very difficult case, I just hope they'll go with what the evidence is. And I think the public would respect that. But it's a political office. An elected politician wants to keep his job. Those that choose to be an assistant state attorney have to exist within that. It's kind of like you have a Jack Campbell or a Willie Meggs franchise, and you have to, you know, if you work at a Chick-fil-A franchise and you decide, well, I'm not going to do chicken anymore, I'm going to do barbecue. Well, that's not what we do here. So if you want to be a prosecutor, you have to, you know, do what the office expects you to do. You know, sometimes some of us some of us have a good career that we don't get, we don't butt heads with the elected prosecutor. Some of us, can get into a period of time where we're at odds with that prosecutor, and then we're no longer a prosecutor. So, and, I fall into that category. So, she wants to be a prosecutor, so she has to work within those confines, and she just can't go and charge more people, even though I think in her heart she would prefer to seek justice against all of them.
Okay. Let's see. I know I'm already taking up so much of your time, so I'll try to wrap it up, but there's always something else I want to ask you. Okay. Well, big thanks to Fancy Fiction for posting this on her Patreon page. Please support her Patreon if you are not a supporter. But this is actually an old filing from 2020. Yeah, it says, well, the order was filed January 2020, but the actual motion to declare Katie as indigent was filed, I think, February of 2019. And I was really surprised because in it, Tara Kawas says something about being paid $20,000 for her work in this action, which seems incredibly low. Granted, back in 2019, they hadn't had the trial yet. But so I wanted to ask you about your comments about this. It was an affidavit filed by Tara Kawas saying that she was charging $20,000, but she hadn't even been paid yet. And it said, due to the financial hardship experienced by Ms. McBanuet's family, due to her arrest and incarceration, undersigned counsel has agreed to give her family some time to pay for her representation. She's submitting it in support of McBanuet's motion to be declared indigent for costs. So can you sort of explain this to us?
Sure. The motion itself is not that uncommon. If an individual is convicted of a crime and the next stage is going to be an appeal, they've hired an attorney, they've hired private counsel, their family, they've provided funds, they've paid for the person, but they can't afford to continue with the appeal. Their attorney has the obligation to file a notice of appeal, and then to file a motion like this, it's not uncommon to then ask for a public defender to take over the appeal. Sometimes the case is still in the trial stage. The attorney will take the case, they'll be paid $10,000 or $20,000 by the family, whatever it may be. And then they say, they file a motion with the court, the client is now indigent for costs, they don't have any more money, but we need to hire experts, we need to have an investigator help us prepare for trial, we need to take depositions, all these things. They apply to the state Justice Administration Commission to get those funds. So it's kind of like having it both ways. I hire a private attorney, I don't use a public defender, but I get the state to reimburse me on costs. I'm not sure what stage this was, if they were contemplating an appeal or if they were contemplating.
No. Yeah, because the motion was actually filed in February 2019.
So they.
Yeah. So I don't know why they did it during this time.
Well, it would seem to fall in that second category in the sense that I'm a private attorney, but I'm going to. And it's been sort of a controversial thing in Florida at times, because if I'm indigent, I should have the public defender. I should avail myself of the public defender, who we have taxpayer funded attorneys for folks that can't afford them. I shouldn't be able to just go to my family and scrape together a bunch of money and hire somebody that can't complete the job, and then I have to get the state, the taxpayer, to help me prepare for trial. It seems like this falls in that second category. It's not that uncommon, but there have been occasions in the state where these things have been investigated and looked at with a dim view, because you really should have the public defender. And there's also an issue whether a family should bankrupt itself hiring a private attorney when they really can't afford it. They mortgage the house, sell things, and so forth. And so on, and it looks to me like that's the second category, that they need this money to prepare for the trial. Now, $20,000, that could be one phase of the case. It's remarkably low if that's the full amount to represent her through trial. That's not a lot of money when you think about the amount of work. And Ms. Kawas is a very passionate, skilled attorney, very dedicated. I mean, it's obvious she put a lot of time into this case. As a lawyer, as a firm, you're not making any money if you take a case like this for $20,000. So there must be some other reason. You really believe in the case very strongly. You really want to help the person, or maybe you get some other benefit out of it, like publicity, or you're wanting to crusade. There's nothing wrong with any of that, but it just kind of explains something about it. Because I mean, I wouldn't take a case like this, a complex murder case, for probably less than 50. And I think even that would probably come down to you're making about $80 an hour when the thing is over with.
Yeah, or less. I mean, plus they had to pay to stay in hotels up in Tallahassee for weeks. That's a lot of money to miss out on. They could have been making money on other clients.
And that's a key point. You can't do anything else really with a case like this. You're doing this case to the exclusion of everything else. You're in the middle of a trial like this. You can't be trying a divorce case, or you can't be doing a probate case or something in the middle of something like this. So
some DUIs, you can't do anything.
Your life is on hold. Yeah, your life is on hold until this is over with. So but sometimes people want to do a case like this for other reasons besides financial, and some of that's probably a good thing, that we have people willing to defend somebody, even if they're not going to make money for it. I'm not sure the whole JAC thing is a great idea, because really, if somebody's truly indigent, we have a public defender system, for a reason for that.
Mm-hmm. Well, have you even heard of other lawyers that defending somebody for free, or say like $20,000?
I have, to be real candid, there was a homicide case up here where I practice in Washington County. And I mean, I said I wouldn't take it for less than 40 or 50, something like that. And I heard later another attorney took it for $17,000.
Oh.
It was much less complex than this case, but, and saying money like that, talking money like that, I mean, it may sound a little crass to people watching the program, but it's like any other business. I mean, if I build houses, would I build a house? Could I be able to build a house for somebody for free, let them live in it, and then get paid? Or, could you go to a car dealership and say, I want that Cadillac, but I'll pay you when it's over with, 2 years from now. Mm-hmm. No other business can survive that way. And really the practice of law is no different. You have bills, we have rent, we have staff we have to pay for, we have, all the supplies.
RDU, CLE,
all these things, and practicing law can be expensive, even though it doesn't seem obvious to just a casual observer, because you think about, well, how expensive could it be? You're not buying tractors or trucks or, but there's a lot of costs beyond that just subscriptions to Adobe and to Clio, Westlaw. It's unusual. I think a case like this, I mean, could easily be $60,000 in billable hours.
Mm-hmm. Yeah. Did you see Mentor Lawyer's video? It was actually several months ago, where he was guessing at how much Katie's defense cost. And I was thinking, well, but the criminal attorneys aren't charging by the hour. Normally it's a flat fee, isn't it? Because I used to work for a criminal defense firm. They didn't bill by the hour.
I'd say most are flat fees, but not always the case. And I think in a higher profile case, there are times where their bill. There are times where you'd have to provide an advance fee or a retainer to go forward. I know in situations where I've met with potential clients and it's a homicide case, it would have, some of them would have been an advance fee, and we would bill by the hour. So it varies. I think in some ways advance fees protect both the client and the attorney, because the client's only charged for the work that's done. The attorney actually gets paid for the work that he or she did. And you take a flat fee on a murder case and it turns into a 5-year case, then not that making money is the only reason we do what we do, but ultimately we have homes, we have families, we have cars and
expenses, mortgages, student loans.
We want to keep electricity on and Wi-Fi on, and so 20 is pretty low, but we may not know all the terms of their contract and stuff.
Yeah. So Fancy says Kawas is despicable and a poor attorney crying like a baby after both trials. What the hell is that? Grow up, immature and self-involved beyond belief. Well, I mean, what's your opinion about that? Have you seen attorneys crying in court after they lose?
Well, and some would cry to try to win. There was a prosecutor in Florida back in the 1950s and 60s, and he was kind of famous for shedding tears in the closing.
Oh.
Like a lot of things, whether it's an actor or other professions, different people have a different shtick or a different personality that works for them. When I said that Ms. Kawas I thought was skilled and dedicated and passionate, that's not to say that I would endorse some of those tactics, or if they're not tactics of letting your emotions show that much. And I think the two are separate things. The person can be skilled at what they do, and still, I don't say that's a model of what I would encourage young lawyers getting into the profession that should do that. But some of it depends on what works for them. Some attorneys can be much more bombastic and fiery in court, and that works for them. It may play in certain geographic areas. It may play in Miami, it may play in DC, but in rural North Carolina or in rural Florida where I practice, coming that aggressive in court may not work with a judge. And, it may be like my cousin Vinny, where the next scene is the attorney riding to the jail being held in contempt, and so with Ms. Kawas, I mean, I think she's very skilled, very passionate. I think Mr. DeCoste as well. Do I think it's advisable to cry and stuff? No, it's probably not a personal choice that I would make. I would try to find another way of showing that I really cared about my client, really believed in her innocence, was really passionate, and defense attorneys once told me when I was a younger attorney, they said, jurors want to see the prosecutor be passionate and care about the case, but they don't want to see the prosecutor be cocky and be, she used another more colorful term, in their personality. So same with the defense. I think you can turn off people, and it's a balance of how you do that. Think about some of the greatest actors and actresses that we know on screen, that they could get a scene just right, that you believe it, you're convinced. But if they just went a little bit further, they would have lost the audience. So you're kind of on a razor edge of how you do some of this. But some of it's just personal. I've seen some defense attorneys will put their arm around their client in the courtroom. My client is innocent, etc. Some attorneys are much more matter of fact. My client deserves a fair trial. My client deserves their rights protected. and it's more subtle. And it depends on the case, and it depends on the people involved, what works best. Miss Kappelman, I think some people, not to pick on her, some people thought, did she display enough passion the first time around? Some people defended her and said, well, that's her personality. I thought she did a tremendous job in the second trial with that balance of just hammering those facts in a believable way, a credible way. She remained above the fray, and it worked for her. Other attorneys would show more emotion, and that would be fine.
Mm-hmm. Okay. Just want to address this here. Sunny is talking about how it reveals that Adelson's funneled money to her family to pay for her defense. Not really, because this motion mentions being paid $20,000 back in early 2019. Granted, as Jeremy mentioned, it could have been just for a specific phase of the case, but I don't think it's totally improbable that some family members could scrape together another $20,000 or even $50,000 to pay for defense. It kind of shows that Kawas really wasn't charging that much, in my opinion. So
I think that's certainly a good way of looking at it.
Yeah, so we still don't know for sure, did the Adelsons funnel money to Katie's defense or not, but yeah, but it sure seems like she has no money coming her way anymore since she had to get a court-appointed attorney for her appeal. So
we may never know, we may never know some of those things. There's some indication that the Adelsons tried to hire other hitmen before they were successful. So could that money be traced? Some things we may never be able to actually have concrete proof of.
Mm-hmm. That's right. Okay. Thank you, Ultra Testosterone. He asks, how much does white collar defense cost for a profession like a physician who gets criminal charges? I have no idea. I think it totally depends on the attorney as well as the client and what kind of charges there are.
It really does. It's like any other profession. Cosmetic surgery can charge more with one doctor versus another. Building a house can charge more with one versus another. It depends, but certainly quite a bit of money. I mean, these attorneys that play in that realm, they don't do it for a chicken feed amount of money. They do it to get a good fee.
Yeah, exactly. Yeah, I'm sure Charlie has already been spending hundreds of thousands of dollars too. Yeah. So when I worked for a firm that did a lot of criminal defense, one of the partners said he would just kind of like look at somebody and listen to them talk about their case and then just sort of like pull out a figure out of his own mind. There was no printed table like a McDonald's where it says this is how much it costs for this and that. So it's a lot of variables.
It's interesting that you say that, because it really is a subjective thing in a sense. You hear from somebody, and how difficult are the facts? How difficult will that client be to work with? You have to sometimes come up with a figure on the fly to make sure you get compensated for your time and you can complete the case successfully. And
that same partner also said that sometimes he would give people the a-hole tax, like if somebody just seemed like a very difficult, annoying type of person, then he would charge them more.
Well, and some people that walk in the door, if they're arguing with me in the initial consultation, it may be I don't take the case because, you cannot get into a trial situation where you have somebody that's working to defeat you at the table across the courtroom as well as sitting right next to you. So, those are some of the variables that, you don't really learn in law school, and you don't really have a book to tell you that. But if I can't work with somebody, if they can't take advice or they can't control themselves, then everything I do to try to help them is just going to sort of go down the drain.
Mm-hmm. Yeah. Yeah. And I do that also. Sometimes people ask, how much is it going to cost for a divorce case or a divorce and custody case? And I don't give any sort of like specific flat number either, because it all depends on the complexity of the case. So Ultra also wants to know, using the wealth of the client to charge more for the case. This is what is scary when one is a high paid physician making hundreds of thousands of dollars and has to pay for a lawyer. Well, I think some people do take into that account. I mean, similarly, if I meet someone that is kind of down and out and scraping by, doesn't make much money, but if I still think that the person could be a good client, then maybe I would charge them a little less.
Well, and I think that's fair. I mean, if you have a little store and you sell food and things like that, somebody is really struggling, you give them a discount on a product, on a loaf of bread. There's nothing wrong with that. As a business owner, I can do that. If I know somebody pulls up in a brand new, $100,000 car, I mean, and they want free samples of something, I may not do that. I think an ethical attorney still will be fair. And here's a good example. I mean, I heard this directly from attorneys in Central Florida. They both have a family law case. The attorneys get together. We know what Judge Johnson is going to do on this case, but let's file some motions. Let's do this. Let's prolong this. We'll bill our clients. So there you're soaking a client that can pay, because you already know what the judge is going to do on day one, but you're going to do all this work and soak the client because they have some money. And you just have to look for somebody that you think has some ethics and hire that attorney. But we don't always know that, because we can't see within a person to know what they're going to do.
Mm-hmm. Okay. Yeah. Okay. Let's try to wrap things up, because we have taken up so much of Jeremy's time. But one thing we haven't mentioned is that Jeremy Mutz is also a published author of several different books, and people have said they've really enjoyed reading his books. You can buy it on Amazon. So this is his profile on Amazon. His first book was called The Chance I'll Take, published in 2014. So it's a crime novel, right?
It's a cold case fiction novel. And thank you for the share, by the way. I really do appreciate that. Sure. And it means a lot hearing some of the feedback. That was my first one. That was kind of a lifelong dream to finish a novel, and really just finishing it was the main thing. I didn't know if I would get to publish it or not, but then it did happen. And then the next one came in 2021 with the same characters. It's called Don't Call It Murder. And I've also published a couple of short stories, and hope to have another novel and a few more short stories out soon. But trying to balance what I do as a day job versus the hobby and the passion that I have, that's sometimes not easy to do all of it. And I really liked your show recently with Jane Kuo, your friend, the author, and I thought that was really cool. And to kind of hear how she writes in 25 minutes a day, and some of the things that I could relate to, because sometimes that's what I try to do as well. Just a few minutes a day sometimes is all I can really devote to it. But it's a passion of mine. It's something I really love. I've grown up, loving crime fiction, and I hope people will enjoy the books if they decide to give them a try. Very much research, very much, I've drawn from all my experiences, and there's probably not a location in the books I haven't walked or researched in some way. So, it's very, I think true to life, or hopefully so.
Mm-hmm. Okay. Cliff wants to know, did you read Stephen Epstein's book?
I did. And I talked to him about it and communicated with him about it a little bit. And I think I was on Surviving the Survivor, and we talked a little bit about the book. I really liked it. I mean, I thought it was a real page turner. And I think we know this case. I mean, most of us have been following this case, but it still was new and fresh and really kept me on the edge of my seat reading his book. I felt like he tried to treat Wendy in kind of an even-handed way. I know some people maybe took issue with that. I thought he kind of subtly inserted some of the things that show culpability on her part, or show perhaps a less than innocent explanation on some things. But I thought he's pretty fair to her. But I really enjoyed the book, and I told him that, and hope he'll write some more along those lines.
Okay, thank you. Okay, 5 wants to emphasize again, Trescott is not a shortcut. Do you agree, since you actually live near there?
I would agree. It is really not a shortcut because it's a very long curved street. So, and I think there are speed bumps on it as well. Mm-hmm. So it's really not a shortcut I would take under. I would really think of no reason why I would do that. The explanation that she gave really didn't make any sense, that she would take that particular route to go where she was going. And I think there's also some issue with the liquor stores. There actually were some closer ones to her point of origination that day. Mm-hmm. But that road is very long with many, many houses, and it's just not a quick path.
Mm-hmm. Okay. Thank you, 5. All right. Any closing remarks then before we say goodbye to our viewers?
Well, I really appreciate it. I've enjoyed it, and it's an honor to be here. I think you're one of the stars when it comes to coverage of this case. I think you've been there providing really good analysis that, you know, whatever the reason, local media outlets don't cover these things 24/7. So I think it comes to podcasters, to authors, to other people to kind of step in, and you're one of the people doing that. I think it's a great thing. Certainly interesting, and I hope, I pray that there is justice for the Markel family, and nothing that can be done is enough to bring Mr. Markel back, but at least we do everything earthly possible in a court system to do that. And I certainly hope that is done for his family's sake. And, I hope that, we'll look back in a year or two with a lot more having been done in that vein.
Yeah. Well, thank you for all your great work in trying to get justice for all these victims' families, and trying to do the right thing within the justice system and the confines of the law. So, okay. Well, thank you guys all for your interest. And next weekend, we're going to have a retired law enforcement officer from Florida come and again speak about the Markel case, because some of us are just totally into it and very much riveted by this whole Dan Markel Adelson case. So thank you all. Jeremy, why don't you stay on for an additional minute if you have time, so sure. I can say goodbye to you personally. Thank you, everybody. Sorry we couldn't get to everybody's questions, but there's just I'm kind of on a time crunch here. So thank you. Take care.